Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm attorney John Redmann.
And hello everyone, I'm Shauna Sanford. Welcome to the show where today we are taking on part 2 of our look into the appellate system. It is one of the major parts of the foundation of the judicial system. Now, if you are involved in a court case and disagree with the verdict, you can appeal. But as we discovered last week, there's lots to learn about how the appellate process works. And we are happy to welcome back Judge Terri F. Love of Louisiana's 4th Circuit Court of Appeal here to Power of Attorney.
When should you appeal a case? How does the appeals process work? Judge Terri F. Love will answer these questions and many more.
But before we bring on Judge Love, John, tell us about your experience there. You were just before the 4th Circuit.
Yeah, it's always so impressive. It's such a beautiful courthouse. The courtroom on the interior is majestic. It's daunting. You know, you have that responsibility on your shoulders. You're asking these the panel of judges. When you go on the Court of Appeals, it's not one judge. It's usually 3. Sometimes it's 5. Sometimes it can be all the judges at once if it's en banc. And you're asking them to reverse, if you're the guy or lady up on appeal, you're asking them to change the outcome of the lower court. Sometimes you're on the other side and you're saying that lower court did fine. Don't listen to the person who brought the case up on appeal. Yeah. Today is another episode on this topic where I'm looking forward to continue the discussion with Judge Love.
There is lots to learn. Coming up next, Judge Terri Love will join the show, so stay with us. We'll be right back. Hello everyone and welcome back to the show. If you ever find yourself in the situation where you need to appeal a court ruling, there are some very important things that you need to know as you begin that process. And today we're excited to welcome back the Honorable Terri F. Love to Power of Attorney.
Judge Love sits on the bench of the Louisiana 4th Circuit Court of Appeal, a position she's held since 2000. Before that, she was Chief Deputy City Attorney for New Orleans and sat on the bench at Civil District Court. Judge, thanks so much for being with us on the show today.
Glad to be back.
Well, we learned so much the last time. We had to have you stay for a second show because there's so much that we just did not get into. And we're talking about the appellate process and trying to understand exactly how that process works, as complicated as it may be to the layperson out there. But the appellate process is not a process that only begins at the end of a trial. It can become involved during a trial, right?
And before the trial.
And before the trial.
During the trial, you have the opportunity to take a writ to our court.
Right. Now, we didn't get to describe that in the first episode of this 2-part series. Why don't you describe some...
A writ is basically a piecemeal ruling almost. The trial judge has ruled on one piece of the case, and a party is not satisfied with that ruling, and they get the opportunity to take a writ to our court. Now, this ruling is based on what is submitted by the parties. We do not look at the full record on a writ. Okay. There are some cases where we may call up the full record, but on most cases on a writ, we're just looking at one ruling and one aspect, and it is the attorney's responsibility who files the writ to submit everything that is needed for us to make that ruling. And on numerous cases, we'll say on the showing made, we decline, and what that means is the lawyer has not provided us with sufficient information to make a ruling. And I always tell lawyers that you should get someone, if you're filing a writ, get someone else in the office to look at it. Because sometimes you know what's there and you assume that it's there, and you give it to someone else and they say, well, wait, where's the copy of this, or where's this? And you're saying, oh, you just make this assumption because you're very familiar with your case, and you don't want to lose your writ just because you didn't file. And that piggybacks into another point that I've been very stressful about in a way, because it gives us some cause at the court, because when you don't follow the rules. A lot of times you have to follow the rules, and I say it creates the stress because a lot of judges do not want to exclude you from court because you didn't follow the rules, because at that point we're not getting the opportunity to make substantive rulings. And we discuss it constantly amongst ourselves, whether you should be given that second opportunity because you didn't follow what was required of you on the first time.
Right.
Well,
And I think it goes back to a lot of lawyers. They assume they know the rules, and sometimes it's best to just always check the rules because they do change.
Right, right.
Well, it just makes sense. You know, when you're the practicing attorney, you want, and from my perspective, doing what I do on appeals, I want to make your job as easy as possible. I want to make sure I've dotted every I, crossed every T, and I serve it up on a silver platter so you go, absolutely everything's here. And then the argument hopefully is short and sweet. You know, I don't have a bunch of...
And on the writs now, on the writs, remember, that's when you get to submit, and then your opponent, the respondent, gets the opportunity to respond. On the appeal, you just have to make sure that everything is in the record.
Well, I think this is great, and we're going to stop right here and explain. The writ is not the appeal. This is just on an issue.
One issue.
One issue that's involved in the trial. So, but it could greatly affect the trial.
Oh, it definitely can affect the trial, because you could have a defendant who's removed in a criminal case. On a motion to suppress, if the motion to suppress is not upheld, then there's evidence.
Yeah, maybe it's a confession that that the defense lawyer was able to kick out of the district attorney's toolkit. If the judge says, "Well, we're going to suppress this confession," you can't use it to try and convict.
This defendant did not receive his Miranda rights, or she did not receive, and so if the confession is gone, that places the DA in a different position in proving his case. So
he's got to go to trial without
In
that.
a civil case, if an insurance company is removed from the suit, then that puts the plaintiff's attorney in a different pocket, because there are not the funds there if they're able to prevail on this civil claim.
All right, so I guess, I'm just the layperson here, so this could really determine whether that trial is going to move forward or not.
Oh, definitely.
Yeah, it
definitely.
could be critical. But go back to something we said in the first episode of, here we are in episode 2, all appeal, anybody who has been through trial, automatically they're entitled to go see the Court of Appeals and have the matter addressed in the Court of Appeals. But a writ, you don't have that right automatically, right?
You have the right to file if the trial judge approves for you to take the writ, and the trial judge is going to approve.
Okay.
You have the right to take the writ. Now the question is how our court rules, whether we rule on the writ, whether we decline to exercise our supervisory jurisdiction. But the most important thing with any appeal or any writ is to know your time delays.
Okay.
Because there are certain time delays that you're going to be guided by. And if you don't meet the time delays, you will not make it to the appeal court.
If you miss the time delays, it's like you never filed the writ at all.
Never filed the writ. And if you don't submit everything attached to your writ that we need to make a decision, then your writ will not be considered.
You'd be shooting yourself in the foot.
Well, while my case would be very important to me, it may not necessarily meet the requirements for an emergency ruling, right? So there are some emergency writs and then others that are not.
Emergency ones are normally when you're in the midst of a trial, or a trial is in the process of beginning. But the determination of whether it's an emergency is made by our court. And in some instances, if we determine that it is an emergency and we need further information, we can stay an ongoing trial.
In other words, tell the trial to stop in its tracks.
Let us look at it. Let us see whether there's an error here. Because the one thing, as I said earlier, we want cases to proceed, and we want the cases to be concluded. We don't want to have to do retries.
You don't, yeah.
You just don't want to have to do that.
Now, what if I'm unsatisfied with the ruling concerning the writ?
You can always take that up also to the Supreme Court, but the likelihood
of that happening
is very slim. And I think what you have to realize is that the trial judge is there to make the calls. The trial judge is there to make these discretionary calls, to rule on the law. We are there in some instances, if you meet all the requirements, to review it. But the Supreme Court is definitely not there to micromanage the trial court, even look at the appellate process. The Supreme Court is there. You have 7 people who are making decisions for the entire state. And they have administrative functions that take time. So you don't want to jog up the courts with all of these things that should be left to the trial judge.
Right, and I don't think that we can stress enough, John and Judge Love, that, again, the appellate court is a court of record. It's not about bringing in new evidence. It's not about retrying the case. It's about what was on, or what is on the record from the trial case. Is that correct?
That's clear. Perfect example. In the NFL game, when the ref goes to the side and looks at that tape,
yes,
that's it.
That's it. Yeah. And so what you all are looking at is a tape, essentially, of what happened in the trial.
And we make our call. We come out and we make our call. And you can't go back in and say, ref, you should have looked at this or looked at that. When he goes stick his head in that camera, that's what he's bound to. So basically, when we're looking at a record, we're sticking our head in, and we're going to make our call. But the thing is, we have 3 people who are looking at it. We all get to have our input. And the final product should be an agreement and a decision amongst the 3 people.
Right. Ruled. It's the majority rules.
The majority rules.
The majority rules.
Democracy.
Democracy at work. It is truly democracy at work. And one of the things, too, that we've been talking about is everybody has the right to appeal. But it doesn't mean that your case is worthy of an appeal. I may not like the ruling. Doesn't mean that the ruling was wrong. Doesn't mean that that case should be appealed, but then that is up to
that's a personal decision. And I think every case, I remember when I was first elected judge, I was questioned somewhere, what is the most important case? Every case.
Every case.
Because every case is important to that litigant.
Right.
Of course.
So therefore, I think the appellate process is open. Now, it's not a process that you can just decide. It's not people's court. It's not where you can go in, and that's one of the problems I think we as jurists have faced, is that the public has these perceptions, and this is why shows like this are really great.
Aren't they? They're just misperceptions.
I'm not an entertainer, you know, and when you watch those judge shows,
you're entertained.
It's a clown show. It's a joke.
Well, I wouldn't call it all
I'll call it a clown show.
That's not the real world. That's not the real how it really works.
And let's just say that process, I think, impedes the process. But I will say this, I believe in working with young people. That's one of my interests, and I bring a lot of young people to the courthouse. And I've brought in some 6th graders and 4th graders, and I've questioned them on certain things, and amazingly, they could answer questions for me adults couldn't. If you walk into the courtroom at the 4th Circuit, my first question is, what is different in this courtroom than any other courtroom? And a young man raised his hand quickly. There's no box for the jurors.
Excellent.
That's because we don't do that. We read what has occurred. And so that showed me that young people are familiar with the trial process, but they're not familiar because there are no shows on the appellate process. I think there was one show years ago where Sally Fields played a Supreme Court justice, and it lasted maybe 3 shows. It's not an intriguing process that Hollywood wants to cover.
But a very important process.
So that's why we have to work very hard to educate the public about our process. And I think you questioned me earlier about people coming in to sit in oral argument. You're welcome to sit in oral argument. The only thing I would say is call us ahead of time and try to get us just some information about the case.
We'll put that contact information on our website so people can reach out. And if you're a student or a teacher watching our show, please reach out to the court. It's fascinating to watch arguments happen in your courthouse.
And I have to give, as we always say, my shameless plug. Our clerk of court, Danielle Schott, is awesome. And I think you're very familiar with her, having had your father serve on our court.
Chief Judge.
And Chief Judge. And that's another thing. We have 12 judges. Some of us are elected out of Orleans Parish. There's some who are elected out of Plaquemine, and the others out of St. Bernard.
I'm going to ask you to hold it just right there because we have to take a break. Coming up next, Judge Love will continue to take your questions and yours as well, so stay with us. We'll be right back.